citing that the governor failed to remove the Attorney General when there was the hatch violation. Mr. Hasselback, thank you for coming again.
You're welcome, sir.
As you know already, I'm not going to repeat it, but I will put you under oath again. Would you kindly raise your right hand? Do you swear or affirm under penalty of law that the testimony that you're about to give is the truth?
I will.
Thank you. Would you again state your name, title, and the agency you represent?
Good morning. My name is George Lloyd Hasselback. I currently am employed by the Office of the Public Auditor as legal counsel, and I'm also the supervisor for the investigations unit.
Thank you, Mr. Hasselback. Just to kind of refresh our memories here, yesterday afternoon's hearing was on Article 10, in which we did receive testimony from Mr. Pai, who is also from the Office of the Public Auditor. We members did raise some questions to Mr. Pai that he felt could be better answered by yourself, as you were I think you had more than one role. You were, with regards to the Attorney General, Mr. Buckingham, I believe, is it correct that Mr. Pai had appointed you as the acting public auditor?
I'd just like to clarify, Mr. Pai and I discussed this yesterday evening after his testimony. Mr. Pai has delegated the investigation and the prosecution of the charges contained in the first and second amendment, the first information and the amended information to me. He did that formally for the allegations surrounding the ARA contract that we spoke about the other day. He did that formally by letter and has appointed me to act in his stead for purposes of those issues because of accusations of bias and such. The allegations contained in the informations with regard to what we're talking about here today, Mr. Pai has delegated that to me, yes, but in a less formal manner. He's delegated that to me because I'm the individual in the office that is generally in charge of investigations and generally responsible for prosecuting those investigations we feel that we are able to prosecute and justified in prosecuting. So that's a long way of saying, yes, he has delegated this issue to me, but I just wanted to be clear to the panel exactly the mechanism by which those things were delegated.
Thank you, sir. Mr. Hasselback, can you explain to the committee members the reason that despite your investigation into the Hatch Act incident, wherein the OPA concluded its investigation and even considered it closed and completed, why the Office of the Public Auditor went ahead to file the first or the information?
Well, sir, I came on board in February of 2012. At that point in time, the investigation, the active portion of the investigation of these allegations had been concluded. Before I go any further, I'd like to clarify to the committee that the articles of impeachment mention a violation of the Federal Hatch Act. That's a federal law. I don't have the authority to prosecute violations of federal laws. The CNMI also has analogous statutes that are similar in effect to the Federal Hatch Act. For the committee's information, the Federal Hatch Act talks about covered programs, and these are programs that are either funded wholly or in part by federal funds. And what the Hatch Act says is that somebody that is in a position in one of those covered programs, they can't use their official authority to influence an election. Now that's the Federal Hatch Act. The charges that Mr. Buckingham faces under the information and the First Amendment information, those are violations of our local CNMI ethics and election law that, again, involve similar legal prohibitions to the Hatch Act. In February, I took over, and again, I inherited the balance of pending investigations and cases at the Office of the Public Auditor. I inquired at the time. I, of course, reviewed the file that concerned the events that are before the panel today, and I noted that we had concluded our active investigation and that we had made recommendations to the governor about how to dispose of the case, and those recommendations were not taken by the governor, and in fact he was highly critical of our investigation, our investigators, and our conclusions in a January 6th letter to the Office of the Public Auditor. Now, we responded with a January 25th letter back to the governor that recognized his disagreement and his criticisms of what we had done, respectfully disagreed with them, and stuck by our initial findings in our report. And it also mentioned that at the time we considered this matter closed and would be taking no further action or making no further comment on it at the time. Now, subsequent to that, it became clear that Mr. Buckingham had continued to violate the law, in our opinion. And that would be the charges, the subsequent charges and the first information concerning other situations that we've discussed before, specifically the $390,000 sole source contract, and we discussed that the other day. At that time, once those facts became apparent and we began to investigate that situation, we realized that Mr. Buckingham had committed other violations of CNMI law. So at that time, we made a determination that since Mr. Buckingham had continued to violate CNMI law, we were going to file criminal charges not only on the newly discovered violations, but we decided to reassess the cost-benefit of filing the charges concerning the issues that are at issue today. So we took another look at it. The initial call was made not to file those criminal charges because of a cost-benefit analysis. We were talking about fairly modest charges with fairly modest penalties. Once we determined that we were going to charge Mr. Buckingham with other crimes, that cost-benefit analysis changed. We made the determination that it was in the best interest of the people of the Commonwealth to include the criminal charges from both the latter section of the first information, about the sole sourced ARA contract, but also that it would be prudent to include the charges that we had considered previously. So we reopened the case, for lack of a better term, and I included those charges as well in the first information, and they carried over to the First Amendment information.
Thank you, Mr. Hasselback. And for the record, even though we have been using the term Hatch Act as the violation or the code that was violated under Article 10 of failure to remove the Attorney General for violations of the Hatch Act, I just wanted to point out that in addition to the Federal Hatch Act, it does also include 4 violations of CNMI law, specifically 1 CMC 8534 and 6705, pertaining to the use of public funds, employees' time or equipment, for political campaigns. Just to clarify for the record, so your reference of your charges is based on local law, is consistent with the allegations under Article 10 of our House Resolution 17111.
Yes, sir. There are some different elements to prove a Hatch Act violation as opposed to prove a violation of local law, but generally speaking, they involve the same legal prohibitions. The individuals identified as covered by the Hatch Act are different than individuals covered by our local laws, but what those two laws say they can and can't do is so similar as to almost be identical. I would like to point out to the panel, there has been, we have filed criminal charges under the local laws. As the panel knows, that case is in the very beginning of the process. There hasn't even been an initial appearance yet. There hasn't been any court determination that violations of those laws have occurred. However, as far as the Federal Hatch Act is concerned, I don't know if the panel is aware of this or not, but it has been brought to my attention that a private citizen filed a complaint with the U.S. Office of Special Counsel. And again, I was not directly involved with this. I'm just bringing it to the panel's attention should they wish to investigate further. The U.S. Office of the Special Counsel is a wing of the Department of Justice, and they specifically handle, among other things, complaints of violations of the Federal Hatch Act. This private citizen wrote them when these events transpired, sent certain things, and received a letter dated October 28, 2011, from the U.S. Office of Special Counsel that, in essence, found violations of the U.S. Hatch Act on the part of Mr. Buckingham, but declined to take any action, and in essence provided a warning to Mr. Buckingham that should he engage in that behavior again, they would take some action. Now, I don't have a copy of that letter other than what I've seen from an internet file, a scan. Again, I just bring that to the panel's attention. So if you make a determination you'd like to read that and take that information into account, that is up to you. But I can speak directly and answer questions directly about the local charges.
Recognize Representative De La Cruz.
Thank you, Chairman. Mr. Hasselback, good morning.
Good morning, sir.
You described basically the meaning of the U.S. Hatch Act and what it encumbers. I had posed the same question yesterday to Mr. Pai, whether he had any knowledge of the U.S. Office of Special Counsel doing an investigation, and if that investigation was in parallel to what the CNMI OPA was doing. The U.S. Special Counsel, namely Ms. Mariama Liverpool, I believe.
I agree. That's the name at the bottom of the letter that I read that was purportedly from the Office of the Special Counsel.
Yes, and I had thoroughly read the letter from Ms. Liverpool, and you are correct that the U.S. federal government, in this case the Special Counsel, the U.S. Special Counsel, would need to first determine whether the subject in this matter, Mr. Buckingham, is covered by the Hatch Act. You explained earlier who would be covered under the Hatch Act, and those that are covered are ones that receive federal grants from the U.S. Department of Justice. Examples of these federal grants include the following. Mr. Chair, bear with me while I read what is covered and the grants that are being received by the Office of the Attorney General, CNMI. The first grant is a Violence Against Women Act grant used to prevent and prosecute violence against women. 2 is a Domestic Violence Prosecution Program grant used to prevent and prosecute domestic violence. 3, Interagency Financial Crimes and Drug Task Force grant used to investigate and prosecute financial crimes and coordinate efforts amongst law enforcement agencies. And 4, a Juvenile Criminal Prosecution Program grant used to prosecute and prevent juvenile crimes. And I read further, as Attorney General, Mr. Buckingham is the head of the Attorney General's office, and as such, it appears normal and foreseeable that in 2010 he had duties in connection with the aforementioned grants, including management responsibilities for the grants and supervising employees working on the grant-funded programs and activities. Again further, indeed, the Merit Systems Protection Board, which adjudicates Hatch Act cases, has long held that employees with supervision or responsibility for the general business affairs of an agency or department receiving federal grants are covered by the Hatch Act by virtue of such supervision or responsibility. Thus, we believe that Mr. Buckingham was subject to the provisions of the Hatch Act in 2010. So, Mr. Buckingham clearly, his office was receiving such federal grants, and thereby Mr. Buckingham would have to be under the Federal Hatch Act provision. Is that correct, Mr. Hasselback?
Yes, sir. I agree with the analysis contained in that letter. I don't think there's any question that Mr. Buckingham during the year of 2010 was somebody who would be considered a covered individual under the Hatch Act.
Okay. Further, in this report by Ms. Liverpool, we next examine the allegations that Mr. Buckingham violated the Hatch Act by asking subordinate employees to attend a partisan political event for Mr. Camacho and using the influence of his employing agency to host this political event. The information we reviewed shows that on August 19, 2010, Mr. Buckingham's executive assistant sent an email to employees of the Attorney General's office stating in pertinent part the following: I am taking this upon myself to inform you all that our Attorney General Edward T. Buckingham and the Office of the Attorney General as a whole will be hosting a gathering for Mr. Joe Camacho on Saturday, August 28, 2010, starting at 4:30 p.m. at the Governor's House. As our AG has said, this gathering is not mandatory, but would be nice to see our attorneys and staff come and enjoy the food. Mr. Hasselback, this statement that was made, do you believe that the attorney or the former Attorney General, Mr. Buckingham, initiated this gathering?
Sir, I believe, and this tracks with the facts that have been alleged in the initial and amended complaint, amended information. I believe that the former Attorney General, Mr. Buckingham, used his position to plan, and well, I'll read it for you. The initial charge. I allege that in his capacity as Attorney General of the Commonwealth of Northern Mariana Islands, he himself, or through members of his staff, all of whom were employees of the Commonwealth of Northern Mariana Islands at the time, did plan, organize, and disseminate information and invitations regarding a gathering hosted by the defendant, the purpose of which, in whole or in part, was to provide a platform for which a then political candidate for public office could address those present regarding his candidacy. I believe that the Attorney General planned and hosted a party. He directed his staff to help him plan and host a gathering. Call it a party, call it a gathering, whatever you call it. It was a gathering of a group of people. And the purpose of which, in whole or in part, was to give a political candidate, a single political candidate, a forum at which to address those gathered. I don't think those facts are in dispute. Now, there are disputes as to what the original plan was, what the subsequent plan was, how it changed. However you wash it out, I firmly believe that Mr. Buckingham arranged for and hosted a gathering, the purpose of which, in whole or in part, was to give an individual running for political office a platform to speak about his candidacy. And I think those facts are backed up by the documentary evidence that we have provided to the panel. You've seen our investigative report. You've seen the documents that were provided to us by Mr. Buckingham. Those documents back up this version of the facts. Those documents, I believe, support the allegations we've placed in our information. So yes, in short, I agree that he performed acts that would constitute a violation of the Hatch Act.
Thank you, Mr. Hasselback. Turning your attention now to a letter that was sent from Governor Fitio dated January 6, 2011. I believe his response to the report. The governor indicated or had stated that, he wasn't interviewed. The candidate wasn't interviewed. Mr. Camacho, Mr. Tom Camacho, also not the candidate, but Mr. Tom Camacho and anyone associated with Joe Camacho's election committee was not subpoenaed. It inexplicably failed to do so. Mr. Hasselback, in your own words, can you explain to the members here why these individuals were not interviewed by the Office of Public Auditor?
Absolutely. It was not necessary to interview them. The information that we had been provided in the interviews that we had conducted had already provided us with sufficient admissible evidence to prove every element of the crime as alleged against Mr. Buckingham. The input of the governor, the input of Mr. Tom Camacho, quite frankly, we made the determination that what those people would have to say would be irrelevant. They may have opinions as to how the facts around this situation shook out, but when you begin an investigation and begin to interview people, there are, quite frankly, an infinite number of people you could potentially interview about a case. Now, you can't interview that infinite amount of people. So what you do is you, again, engage in a cost-benefit analysis. You begin to interview people, and you begin to say to yourself, when do we have enough? The determination was made after the interviews that were conducted, as reflected in the report, that we had interviewed enough people. Now, you talk about, the questions are going to come up about sufficiency of evidence. We interviewed Ms. Frida Demopon, the then executive assistant to the former Attorney General. Ms. Demopon had quite a bit to say, and I think that once we get to the questions about the sufficiency of the evidence we had, I'll be happy to talk about what she had to say, but the long and the short of it is, we didn't need to interview anyone else. Now, you've brought up the January 6, 2011 letter. The section to which you're referring accuses the Office of the Public Auditor of failing to conduct a thorough investigation and criticizing what it says that there is a lack of factual finding and a lack of legal analysis, well, that's fine, but I disagree. I believe that there has been a thorough enough investigation. I believe that there have been sufficient factual findings, and I believe that there has been sound legal analysis. Otherwise, I wouldn't have filed these criminal charges. I filed these criminal charges because, as it states in our January 25th, 2011 letter back to the governor, we disagree. And that's fine. People often disagree with the sequence of events when criminal charges are filed. It happens all the time. The court, and either the judge or the jury, depending on how severe the crimes are, that is the body that determines which version of the truth is true.
Thank you, Mr. Hasselback. On the same letter, would you agree with the governor's contention when he stated that you have acknowledged his concerns over the breach of confidentiality? Did OPA ever acknowledge the governor's concern over this breach of confidentiality? And I believe this is with regards to the report.
Yes, sir. I can only speak to my knowledge of the documents that are before me. Now, if you all remember, there was some concern at the time, voiced very loudly by the former Attorney General, that that the Office of the Public Auditor's public comment that a report had been forwarded to the office of the governor was a breach of the confidentiality laws. Now, I do not believe that there was an acknowledgement or an agreement with that statement. I think that there was, as you can see in the January 25th, 2011 letter back to the governor, I believe it's the fifth paragraph down, it reads, "We have also noted your concern about confidentiality. In an earlier letter, we acknowledge that OPA may have inadvertently compromised the confidential nature of the investigation by stating to the press that a report had been forwarded to you. We may have overstated the effect of that statement." Now, again, I believe that that's an ancillary question to why we're here today. Whether or not the statement to the press that, yes, there has been an investigation, and yes, a report has been forwarded to the Office of the Governor, whether or not that was a breach of the Office of the Public Auditor's duties to keep reports confidential, and I don't agree that it is, but whether or not that is a breach of the confidentiality rules is, quite frankly, irrelevant to the question of whether or not Mr. Buckingham violated federal and local laws, and the ultimate question that the panel has to ask, whether or not the governor is was somehow obligated to remove him from office for that. I mean, this is a question you may ask me, and I'm happy to answer it, but I mean, I have to ask the question to you. This doesn't seem to bear upon the facts that the panel is here to talk to me about today.
Thank you, Mr. Hasselback. And just two last short question. And this is a term that is, I guess, normally used in a courtroom proceeding. But do you believe that the former Attorney General, Mr. Buckingham, violated the Hatch Act beyond a reasonable doubt?
I believe that I have, and I have to answer you in specific legal terms because that's because of who I am and what I do for a living. I believe that I have sufficient admissible evidence that when presented before court will prove beyond a reasonable doubt all of the elements of the crimes that I have alleged. Now, this panel has, specifically you have already laid out your reasoning that you seem to agree with, that Mr. Buckingham is a covered individual under the Hatch Act. I don't believe those facts are in dispute. I believe that, given that evidence that I have, that I believe will prove the local charges beyond a reasonable doubt, I also believe that that evidence would prove the requisite bad act to constitute a violation of the Hatch Act. In short, I believe that the evidence that we have presented to the panel already, and that will eventually be presented to a court of law, would prove beyond a reasonable doubt that Mr. Buckingham has violated both federal and local laws. But, sir, I will not have the opportunity to present that in a disposition over the federal laws, as I'm not a federal prosecutor. So I can speak about it in the hypothetical, but I can't really speak to it directly.
Thank you, Mr. Hasselback. And I guess my last question is, do you believe the governor of the CNMI, Governor Fitio, had knowledge that his own Attorney General had violated the Hatch Act?
I can't speak to the governor's understanding of the Hatch Act or his knowledge of what the Hatch Act constitutes. I do believe that the governor knew that Mr. Buckingham was going to host this gathering. I believe that the governor knew that the purpose of this gathering, in whole or in part, was to provide a candidate for a platform for which to speak. I actually believe, because of the documentary evidence I've gathered, that the governor directed Mr. Buckingham. Well, let me back up. I believe that Mr. Buckingham was directed. There's an email that we have mentioned, and I think it's a good time to take a closer look at that email. That email was sent from a gentleman, or is purported to have been sent from a gentleman, I believe his name is Tom Camacho, who the email reads, in part, "Hafa-day, friends. The Committee for the Friends of Joanne Camacho for U.S. Congress 2010 has scheduled an important meeting and is now respectfully requesting everyone's presence tomorrow, 11:30 a.m. at the Saipan Royal Resort. The purpose of this meeting is to discuss and organize subgroups at the precinct level, as well as strategies in moving forward with new efforts. Updates on the upcoming scheduled gatherings hosted by the Friends for Joe will also be covered. In the updated schedule events, you will notice three things, and one of those things mentioned is that Ed Buckingham and company will host this gathering at the governor's residence beginning at 4:30 p.m. Thank you. We sincerely appreciate your efforts." Now, when taking that email in conjunction with the information provided by Ms. Demopon, she stated that she first found out about the event immediately after Mr. Buckingham attended this luncheon. So the sequence of events, as I believe they unfolded, and I believe they are backed up by documentary evidence, is that Mr. Buckingham attended a luncheon hosted by a political group. Mr. Buckingham attended a luncheon hosted by a group whose purpose was to gather and discuss their ability to get a candidate elected into office. Immediately after that meeting, and one of the things on the agenda of that meeting was discussing gatherings to provide that candidate with a place to speak. Immediately after that meeting, Mr. Buckingham returned to his office, and I don't know whether it took place through a phone call initially or a face-to-face meeting, but Mr. Buckingham then reached out to his executive assistant, whom on numerous occasions Mr. Buckingham would say spoke with his voice. I mean, this was an individual, Ms. Demopon is an individual who was vested with quite a bit of authority by Mr. Buckingham. I mean, this was his executive assistant. So he returns after this meeting, he speaks to his executive assistant and says, "I want you to plan a function. I want you to tell our employees about it. I want you to encourage our employees to attend." Now, much has been made about whether or not those employees were compelled to attend. That's irrelevant. Mr. Buckingham, the evidence shows that Mr. Buckingham hosted a party to give a political candidate a place to speak. That political candidate showed up and spoke there.
Thank you, Mr. Hasselback. I'll yield, Mr. Chair.
Vice.
morning.
Good morning, ma'am.
Mr. Hasselback, can you tell us where were you employed prior to your being hired by the Public Auditor's Office?
Prior to working for the Public Auditor's Office, I worked for the public school system. Specifically, I was employed by the Board of Education as their legal counsel.
Prior to that, where were you employed?
Prior to working for the Board of Education, I was employed by the Office of the Attorney General at the Criminal Division.
Criminal Division. And what was your position title when you were with the Attorney General's office?
I had a few titles during my time there. I initially, I believe it was round about May of 2009, and my apologies if the time slips away from me. I believe it was the spring of 2009 when I initially began working for the Office of the Attorney General in the Criminal Division. At that point in time, I was an Assistant Attorney General. I was assigned primarily to prosecuting domestic violence cases. October of 2009, I was appointed as the acting chief prosecutor for a period of about 90 days. After that period expired, I went back to being the domestic violence prosecutor until the time that I left the Office of the Attorney General.
When you say you left the Office of the Attorney General's office, was that what kind of a personnel action was that? Was that a resignation?
I resigned my position because I was taking a new job with the public school system.
And I would like to ask to verify and to get the information exactly from you. Were you on good terms with the Attorney General himself while you were employed in the Office of the Attorney General?
Do you mean professionally or personally, ma'am?
Both.
I didn't really have a personal relationship with Mr. Buckingham. The only contact I really had with Mr. Buckingham was professional, through work. I believe we had a decent working relationship for most of the time I was at the Office of the Attorney General. I did, however, resign my position because I believed I was being asked to do things that were asking me to violate rules of ethics and potentially commit crimes. I didn't like what I was being told to do. I didn't think what I was being told to do was proper or ethical, and I resigned my position and sought other employment.
And you have indicated those to the former AG?
Yes, I did, ma'am.
Do you have something in writing to that effect?
I have, yes, ma'am, I do. I have emails. I emailed my resignation to Mr. Buckingham. I don't believe that my resignation specifically mentioned the reasons why I was resigning. I do have emails between myself and Mr. Buckingham discussing some criminal cases that were the cases that led to my feeling that I wanted to work elsewhere.
So how did you feel at that time when you resigned?
I felt that I didn't want to work for Mr. Buckingham anymore.
So you said that you work with the public school system as their legal counsel, the legal counsel for the commissioner or for the Board of Education?
The organization of the public school system is such that the Board of Education has legal counsel, and that legal counsel is, you can think of it as in-house counsel to a company. The Board of Education is the board of directors of the company. The Commissioner of Education does not, as far as I know, and while I was there, didn't have her own legal counsel.
Mr. Hasselback, when you first appeared before the committee, I remember that I was the one that asked you if you were aware of the letter written by the public auditor to the governor dated January 25, 2011, saying essentially that the case on the ethics, the report and recommendations of the office on the ethics regarding investigation on the AG's involvement with the dinner that was hosted at the governor's residence. I asked you at that point whether you were familiar or that if you were aware of that particular letter, and you said that you were not. Did you say that?
Yes, ma'am, I did. I didn't have the letter in front of me, and I wasn't sure exactly to which. There was a lot of correspondence that occurred right around this time, and I wasn't sure what you were speaking of. I have reviewed that correspondence, and I am familiar with it now.
As the chief of the Office of Investigation for the public auditor's office, handling a case that is so important, why did you tell the committee that you are not aware? Are you trying to sidetrack from my question, or
No, ma'am, I'm not trying to sidetrack your question at all.
This is a letter that's very important.
Yes, ma'am.
In fact, it's the letter that was written by the public auditor, making it very crystal clear to the governor that he was not going to take any further action on the recommendations, on further action on what he has given to the governor with regards to the investigation that they did on the AG. So wouldn't you, I mean, I'm not trying to put words in your mouth, but isn't that a very important letter for you not to be aware of as the chief of the Office on Investigation for the Public Auditor's Office?
Well, ma'am, first of all, I disagree with your conclusion as to what the public auditor said. But to answer your question...
Well, excuse me, I'm just reading it out. I didn't make it up. The second paragraph of that letter, and I have the letter right in front of me, the public auditor went on crystal clear that first and most importantly, we agree with you, and he's now talking to Governor Fitio, that the matter is closed and confidential. OPA has fulfilled its constitutional and statutory mandate by issuing its findings and recommendations to you. No further action is contemplated. And I'm not making that up, and this is not a conclusion from me. I'm just reading it from a letter.
Yes, ma'am, but I disagree as to the impact of that paragraph. You seem to be of the opinion that that paragraph stands inviolate and that the public auditor at the point in time of January 25th, 2011 made a decision, and that decision is final and can never be reviewed, and the public auditor's mind can never change. I disagree. I believe that on January 25th, 2011, a decision was made to take no further action at that time on these criminal charges. But I believe that later on, that decision was reviewed, minds were changed because the situation was different. I don't think that...
Can I just stop you right here? The public auditor said when he came in yesterday that there is something in writing that he would present to the committee, essentially saying that the matter has been reopened. Do you have that?
I don't have that with me today, no, ma'am.
And can you give us that copy of that letter right away?
I wasn't privy to the public auditor's testimony yesterday. I'm not sure what letter to which he's referring or to which you're referring.
Because I'm going to ask, I mean, when you were tasked to do the investigation, was there something in writing from the public auditor saying that the case is reopened?
I am aware of a document written by the public auditor, signed by the public auditor, delegating me to investigate and, if necessary, prosecute the issues surrounding the sole sourced ARA contract. I am also aware that the public auditor delegated to me the duty of investigating and, if necessary, prosecuting these other violations that we've been discussing today. When I took over...
I'm sorry, just so that I'm very clear, meaning that that letter is reopening the case on
No, ma'am.
investigation on the AG with regards to the party at the governor's place?
If you would you like me to explain the process through which we reopened this and decided criminal charges were justified?
Yes, I'm very, very interested.
Okay.
It's very, very important.
Well, ma'am, again, I took over at the I took over at the investigation division in February of this year. I began reviewing all of the pending cases and all of the cases that we were currently and had recently investigated. Some of those included investigations of the former Attorney General. I made the inquiry at the time because I was not privy, nor was anybody else, privy to the internal workings of OPA about this stuff when I was not a member of OPA. So I asked, one of the first questions I asked upon arrival, I spoke to the public auditor and I said, why did the office not charge Mr. Buckingham with violations of the Ethics Act and violations of CNMI election law previously? I had discussions with Mr. Pai and I had discussions with another attorney that works with the Office of the Public Auditor. I was informed that at the time the determination was made to allow the governor an opportunity to handle it administratively because, again, the cost-benefit analysis washed out that it wouldn't have been in the best interest of the Commonwealth to file those charges at that time. Time went on, and we began investigating Mr. Buckingham for other criminal charges. We came to the conclusion that we had sufficient admissible evidence to prove all of the elements of these other criminal charges. At that point in time, we re-examined the relative cost and benefit of filing criminal charges related to the matter before the panel today. At that time, we decided that since the situation had changed, we were justified in reopening the situation and filing criminal charges on all of it.
So that I do not lose you on this, what are those criminal charges, and did you do another investigation? Maybe the committee members have that document on an investigation, a formal investigation taken on other cases, matters that you take to be very relevant and therefore be the reason for you to reopen the case, for the public auditor to reopen this case?
Are you asking if there was further investigation about these?
You're saying that you are based on complaints filed, an investigation or some sort of actions revealing that the Attorney General violated our Commonwealth laws, that you are going to reopen the case. So what are those? Do you have anything formal in writing saying that that the Attorney General violated our laws?
Yes, ma'am, I do.
So where are they?
Well, that is the report by...
I only have in front of me the report that was done on the AG on his involvement with the party that was held at the governor's place. So it's very, very important because I'm not going to get away from this letter. I want to know what was the motive. Was there a motive? What was the reason for us reopening the case when it was very crystal clear? I don't have to be an A student in English to understand what's in that letter that is dated January 6, 2011 from the Public Auditor's Office to the Governor, to Governor Fitio.
Mr. Chair, for information.
Point of information.
Point of information.
Go ahead, Representative Tip-Tip.
Thank you, Mr. Chair. The question that the Vice Speaker is seeking is also provided to the members from the dusisticum that we were provided, and it's called Audit Investigation Requests, and there were 3 of them from respective community members requesting, this is a request to OPA to investigate.
But those are requests, but
That's
were
that's
they already? Have they already? I'm
I
asking
think that's
if
what
there
the
are.
just to clear the question, and that's what the document in front of us is saying, that whether it's reopened or not, it's basically saying that the case is closed, but then other complaints, requests for investigation came in, and so that's what they went on further after the letter from the OPA. But and I'm thinking that the reason why we're not getting direct answer from the gentleman is that it's a confidential letter, and even the confidential report is not by the confidential report was from the legal counsel Joseph Przyuski, and then you have the confidential response from the OPA, not CCing anybody, but only directly to the governor.
Thank you.
I can address the panel members' question.
Please do.
Ma'am, I believe you're asking me what reports or documentation triggered the re-examination of the criminal charges against Mr. Buckingham that were shelved by the January 25th, 2000 letter. Is that correct? You're asking me what caused us to re-examine the situation.
To reopen the case.
And you all have a copy of this, on July 14th, 2011, the Office of the Inspector General of the U.S. Department of the Interior concluded a joint investigation between DOI, OIG, and OPA regarding allegations of criminal conduct surrounding the award of a $392,000 and change sole source procurement contract. When we reviewed that report indicated, and when I reviewed that report indicated that not only was that contract in violation of Commonwealth law, but that the actions of the Attorney General at the time in approving that contract violated Commonwealth law. So that is the next instance where I became aware, because of this documentary evidence gathered, that I believed I had sufficient admissible evidence to file criminal charges against Mr. Buckingham. So to go back to the beginning, our office conducted one investigation, let's call it Investigation A, concluded that Mr. Buckingham broke the law.
Mr. Chairman, can I just interject at this point?
I will allow that, but I would turn it back over to the witness to finish the timeline that he was about. Vice, I'm hesitant. Can we just allow him to finish, and then you would pose the next question?
Sure.
Please finish.
I do want the committee to know that I am attempting and doing my best to give very direct answers here. I don't wish to have anyone believe that I'm trying to hide anything. So let's go back to that timeline. The Office of the Public Auditor gets a report that perhaps the Attorney General has broken the law. We conduct an investigation. That is Investigation A. We make conclusions that yes, indeed, the Attorney General did break the law. At that time, we decided that prosecution of those charges was not the route that we wished to go at that time. We decided to allow the governor an opportunity to handle this issue administratively. The governor declined to do so and disagreed with us. We reiterated our stance and stood by our report and conclusions, and we said, for the time being, as you have pointed out, ma'am, no further action is contemplated. Then we received another complaint about the Attorney General. We conducted another investigation. We uncovered facts that I believe support criminal charges for other charges against the former Attorney General. At that time, we reopened, we re-examined whether or not we wish to file criminal charges as to the first investigation. Let me be very clear. There is nothing illegal, unethical, or improper about re-examining our stance on that first criminal investigation. There is no Commonwealth law that prevents it. There is no rule of law of which I am aware that prevents it. There is no ethical burden upon me which prevents it. In other words, there was absolutely nothing improper or wrong with changing our minds and deciding to file criminal charges based upon the Attorney General's actions in hosting a political function.
Can I come in now?
Thank you, Mr. Hasselback. Vice, please proceed.
Just reading the findings and the recommendations of the public auditor on the former AG's ethical behavior.
Are you referring to the December 13th, 2010 letter?
I'm talking about the party that, with regards to the event.
That's our December 13th, 2010 letter, ma'am? I just want to make sure. I want to make sure.
Still talking about the report, the findings, and the recommendations made to the governor with regards to the former AG's involvement at the party at his residence. My concern here is, that incident occurred in 2010. The Office of the Public Auditor was very, there was no ifs and buts about it. It's very clear that the AGs of the Attorney General violated criminal prohibitions of the Ethics Code Act. And this, I'm just lifting the information, the findings, the OPA's statement in his December 13, 2010 letter to the governor, outlining the serious conclusions that he has on the AG's actions. This was in 2010. My concern here is that the findings were very serious. I mean, just reading the report. And then at the back of the report, it says that the Public Auditor's Office has chosen